Okay, this is file 23-21634-FH and 24-21869-FH. People versus Jessica Lynn Laux. We're here today for pretrial conferences in both of those cases. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
E.B. McClure on behalf of the people.
Rhonda Underwood on behalf of Ms. Laux, Your Honor.
Okay, and Ms. Underwood, where do we stand with Ms. Laux cases today?
Your Honor, there have been discussions, but Ms. Laux is just a few days out from having had a cesarean, Your Honor, and she's recovering at home. I would ask for another pretrial about the end of September, and either we'll resolve this matter or send it.
All right, Ms. McClure, anything you need to address from the people's side?
Just that the most recent note from this week was that Mr. Sneed had not heard back from Ms. Underwood about their plea discussion. So I would just ask before the next pretrial that she reach out to him and talk to him.
All right, let's set it for September 18th at 8:15.
And I will be more than happy to do it in order for you with Floor's permission, Your Honor.
All right, your audio broke up a little bit there. I don't know if Ms. McClure heard that. Ms. McClure, can she have your permission to sign the stiff in order?
Yes, that works.
Okay. All right, so Ms. Laux, your next date, you'll need to log back in on September 18th at 8:15 a.m. I think we lost Ms. Laux at some point during that. I don't see her on my screen any longer. So we will send her a notice.
Thank you, Your Honor.
Right, the gentleman that just joined the meeting in the orange shirt, are you able to hear me?
I am here, sir. Yes.
And you are Troy Clymer?
Yeah. Yes, sir.
All right, this is file 09-14137-FH, People versus Troy Lee Clymer. We're here today in regard to a bench warrant. Sir, again, you are Troy Lee Clymer?
Yes, sir.
Have you received a copy of this warrant, Mr. Clymer?
No, sir.
Sarah Brenner, Assistant Attorney General for the People, Your Honor. Your Honor, the defendant was previously represented by attorney Bob Jameson. And so I don't think he's represented at this point. I don't know who would have sent him the bench warrant, but he's been in bench warrant status since about 2009, like November, December 2009.
Yeah, I'm aware of that.
Okay. And Your Honor, he's been making his child support payments since he's been gone. That's why I didn't object to him appearing via Zoom from Florida. His arrears just started at almost $44,000 and they're now down under $6,000. So just to update the court where we're at, he was on a delay of sentence. And then we had accelerated and then he failed to appear. And so that's kind of where we're at on the underlying case.
All right, so how do you want to proceed with respect to the underlying case?
We're going to need to schedule it for sentencing. Since he has been paying since he was gone, I'm still going to give him the benefit of a reduction to an attempt, just so that he will still have some repercussions for being gone for so long, but to also reward him for having paid while he was gone. So we'll need to schedule him for a final sentencing and have him cooperate with probation for a PSI so we can get him sentenced on that reduced charge.
All right, so Mr. Clammer, you were previously represented by Attorney Robert Jameson in this case. He has since passed away, so I will advise you at this point, you do have a right to be represented by an attorney. If you can't afford an attorney, then the court will appoint one for you at public expense. Do you understand that, sir?
Yes, sir.
Do you want to be represented by an attorney?
I don't think I need one, sir. My payments will be paid by probably the end of the year. I mean, I'll be all caught up with everything. I mean, what do you suggest, sir?
I can't make a suggestion. If you want suggestions, you need to say, I want an attorney, and then talk to an attorney about it.
I think the prosecution is gonna pretty much, she's probably right on like the sentencing later on.
Okay, Mr. Clymer, I can't have a discussion with you about what's going to happen with the case. I need to do what I've done, which is advise you that you have a right to an attorney, and
Yes,
we'll get one for you if you don't have the money to pay for one. What I need is an answer from you as to whether you want an attorney or not.
yes, sir.
Okay, do you have the ability to pay for your own attorney?
No, sir.
All right, so I will appoint the public defender's office to represent you. Ms. Underwood, do you have the information on this case?
I do not, but I'd be happy to talk to Mr. Clymer and we can move things along.
All right, I will put you in a breakout session with Ms. Underwood, Mr. Clymer, if you give me just a moment.
Yes, sir.
Are you serious? They're going to put you on some kind of thing. Don't agree with all stuff.
Your Honor, are we going to be scheduling this for a sentencing date then and setting aside the bench warrant, or are we going to do something after he talks to Miss Underwood?
I would presume we're just going to set it for a sentencing, but I don't know what they're going to talk
Okay.
about with breakout
All right.
sessions.
All right, I'll hang out. Thanks.
Come here.
Okay, Ms. Laux, I apologize. You were in the breakout room and I left you there, but your case has been adjourned to September 18th at 8:15.
September 18th at 8:15.
Correct. So you just need to log back in on that date with the same Zoom information that you used today.
September 18th, 8:15. Thank you so much.
Okay, thank you.
Bye.
All right, Mr. Murphy, are you ready to proceed with Mr. Flores?
Yes, Your Honor. Flores.
Okay, this is file 24-21845-FH People versus Raymond Flores. We're here today for a pretrial conference in this case. We are proceeding today partially in person and partially by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
BB McClure, on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Flores.
Right, and Mr. Murphy, where do we stand with Mr. Flores's case today?
Yeah, I had some discussion with the prosecution with Mr. Bayonetto about this case. I was going to ask if we could adjourn for another pretrial. I'm hoping to get some further negotiations and get the offer changed at this point. I believe this is the first pretrial, so I'm hoping the prosecution would have no objection nor the court. So I believe that it'll be fruitful to adjourn for another pretrial short of setting it for trial at this point.
Okay, Ms. McClure, anything to address from the people's side?
No, I have no objection.
Sorry, text Jim Daly. Congratulations.
All right, Mr. Solid, you need to mute, please.
Okay, sending.
Oh, I'm sorry.
All right, Mr. Murphy, how far out are you?
Whatever fits the court schedule best. I'll probably only need about a month or so to get clarification as to whether or not we're going to get the offer I'm hoping for. And at that point, I think the negotiations wouldn't be any more fruitful. So again, 30 days or whatever fits the court schedule best.
Let's go with September 11th. September 11th at 8:15.
Yes, Your Honor. Thank you.
All right, anything else to address in this case?
Nothing further from the defense, Your Honor. Thank you.
Nothing on behalf of the people. Thank you.
Okay, and Mr. Murphy, you'll do that stip in order, please.
I will, Your Honor. Thank you.
Thank you. Okay, Mr. Mawad, Mr. Sherwood is here in person. Are you ready to go with him, or do you need to speak to him?
No, Judge, I spoke to him quickly this morning and we are ready to go.
Okay, Mr. Sherwood, you want to come forward and stand at the podium, please? Okay, this is file 24-21855-FH. People versus Charles Thomas Sherwood. We are here today for a pretrial hearing. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record?
B.B. McClure, on behalf of the people.
Elias Muwad appearing on behalf of Mr. Sherwood.
All right, and Mr. Sherwood is here in the courtroom in person. So Mr. Mawad, where do we stand with Mr. Sherwood's case today?
Judge, Ms. McClure and I talked yesterday about seeing if there were medical records pertaining to the victim's injuries. I would ask, and because if there are, it's going to take a little time, would the court give us a late September date to see if it exists? And then I think my client, Mr. Sherwood, and I are going to have to talk about the next step, and hopefully we'll have a decision made by the end of September, Judge.
Is there anything you need to address from the people's side today?
No, and I wouldn't even object to going into the first part of October, just because then I'll be in a pretty lengthy trial and I might not have a chance to talk to Mawad at the end of September. And I think we're both on the same page. If we don't get it resolved, we'll be ready to set it for trial then.
All right, how about October 9th at 8:15?
Okay. I will prepare the order. Ms. McClure, can I sign your name to it?
You can.
Okay, great. And I'll just send you a quick email reminder what we're doing. And I've got the other case I got to do some stuff on too.
Yep, and I did a further investigation request for those medical records, so hopefully they get those to me.
Okay, it does look like we need prints in this case, so I'm going to do an order for fingerprints.
Judge, on October 9th, I have in the book arraignments only, no criminal docket.
Okay, can we do October 16th instead of October 9th?
Fine with me, Judge.
Yes.
Okay, so October 16th. And again, I'm going to do an order for fingerprints. So Mr. Sherwood, you'll need to go back to, looks like Rollin Township who was the arresting agency in this, and arrange to have your fingerprints taken for this file.
The state police requested.
Okay, you'll need to contact them. Okay, anything else we need to address in this case today?
Oh, thank you, Judge. Thank you very much.
Okay.
Mr. Sherwood, I will give you a call. Thank you, Phoebe. Appreciate it.
Yep.
So, Mr. Sherwood, you were all set for today, sir. Mr. Murphy, I have Mr. Gritzmaker on Zoom.
I need to speak with him. Can I connect on Zoom and do that real quick?
Yeah, that's fine. Mr. Glazer, are any of your people here in person?
Thank you.
Mr. Taylor's, but I need to have, I think that Jackie was gonna, but she, I think somebody used to call her to have her come.
I think she was waiting down here because I thought she had to do some amended informations before just depending on how it was gonna go, I guess. So do you want her to zoom in first and then?
I need to talk to her, either up here or I'll run down there, whichever she wants.
Okay, let me let her know.
Recent profits.
All right, she's gonna pop up.
Okay, Mr. Gritzmaker, I'm going to put you in a breakout session with Mr. Murphy. Go back to claim. All right, we are back on the record in file 09-14137-FH, People versus Troy Lee Clymer. Ms. Underwood, do you know how Mr. Clymer would like to proceed?
Yes, Your Honor. As far as the underlying case, we would like to schedule this matter for sentencing. As far as the bench warrant, Mr. Clymer is willing to take responsibility for that. However, we hope that the court would consider setting it aside. Mr. Clymer had some interesting things happen during his extradition process. The van that was taking him back to Florida was in an accident and he was laid up for a while. And when he got up back on his feet, he was very scared and just was paying his child support.
You tell the judge that you were never.
Okay, so what I'll do is let's set this for sentencing on September 12th at 8:15.
I'm sorry, what was that date again?
December 12th, 8:15.
September 12th.
September 12th.
And so what I'll do at this point is I'll enter a not guilty plea for him on the contempt. And if things go smoothly between now and then, and we get the sentencing accomplished on September 12th, I'd be willing to set aside that bench warrant.
Thank you so much, Your Honor.
Thank you.
I need information.
All right, so Mr. Clymer, I'm going to put you in a breakout session with Ms. Holly. She's going to collect all of your contact information so that they can be in touch with you to do a pre-sentence investigation interview so that they can get your pre-sentence investigation report completed.
Yes, sir.
Thank you, Your Honor.
Okay, thank you. And let's see, the gentleman at the jail, you're Mr. Raymond?
Yes, Your Honor.
Okay, your attorney is with another client right now. As soon as he's done with that one, I'll have him speak to you.
Okay.
Okay, Mr. Sala and Mr. McCready, I've got a plea agreement here for Mr. Highland. Are we also going to need an amended information on that?
Yes, Your Honor. One is going to be filed in the next probably 2 minutes.
Okay. Mr. Glazer, I have Allison Scholes on Zoom.
Okay.
To proceed with her case.
Yes, I do.
Okay, this is file 23-21524-FH People versus Allison K. Scholes. We are here today for a pretrial conference. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record.
Phoebe McClure, on behalf of the people.
John Glazer on behalf of Ms. Scholes.
All right, and Miss, I can't see you. Can you point the camera at yourself and identify yourself, please?
Yeah, hold on. I'm breastfeeding my baby. I'm here. Allison K. Scholes here.
All right. So Mr. Glazer, where do we stand with Ms. Scholes' case today?
Your Honor, we adjourned this a number of times. The original idea was that she was going to go do enhanced or not enhanced treatment court.
The TBI.
The thing where she pays off and
Economic crime unit.
What's that?
Economic crime unit.
Yeah, that's it. I was drawing this blank. Your Honor, the problem Ms. Scholes has is I don't think she can do that any longer. Her husband has left her and she's got 4 kids, and And the reality is that I don't think she's gonna be able to pay it. She originally thought it was like $1,300. I talked to the prosecutor yesterday, it's more like $4,900. I think Ms. Mir said she would offer a misdemeanor. Were you gonna make it deferred, Phoebe?
No, because I didn't think she could pay that much restitution during probation.
Well, if she does, could it be deferred if somehow over probation she pays it?
Yeah,
So what I'd like to do, Your Honor, is adjourn it just to next week. I want to go over this with Ms. Scholes. I'd rather do it in my office. And I think instead of doing the economic crime, we'll probably just do a misdemeanor next week.
yeah, and I apologize to the court too. I think part of the confusion was that both Mr. Glacier and I thought she was participating in the diversion program, and we found out that she was not. So our notes to us weren't super clear. So I think if we just have 1 week, we can finalize
Yeah,
something.
It would be good to do diversion, but I don't see where it's going to be possible for her to do it.
So next week's getting a little busy already. Can we do August 21st?
August 21st. Is that what day? Is that a
It's
Wednesday?
a Wednesday.
Yeah, I can do that.
So we'll adjourn it to August 21st at 8:15. Mr. Glazer, can you do that, Stephen?
I can do that. Ms. Scholes,
Yes.
you set up an appointment to come in and see me this week or next week, okay?
Okay, I'll call right now and get an appointment with you.
Set something up with Leo, that's fine. Thank you.
Thank you.
Let's see. Okay. Mr. Murphy, are you ready to proceed with Mr. Kritzman?
Yes, Your Honor.
This is file 24-21, I'm sorry. 843-FH, People versus Keith Dwayne Gritzmaker. Here today for a pretrial conference in this case, and we're proceeding by video conference and in person. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure, me up the people.
Matthew Murphy, appearing back, Mr. Gritzmaker.
All right, and Mr. Murphy, where do we stand with Mr. Gritzmaker's case today?
Your Honor, at this time, we're going to ask for another pretrial. I had emailed the sobriety court coordinator asking her to have Mr. Gritzmaker screened. That was some time ago. I guess they weren't able to connect. I emailed her again over the weekend and had no response. I believe this is the first pretrial. There is an offer in place for Mr. Gritzmaker to plead in OWI 3rd, but we wanted to see if he would qualify for entrance into sobriety court before we made a decision on whether to accept that or not. So we're asking again for another adjournment, just for one more pretrial, whatever fits the court schedule best. 30 days or whatever. The prosecution would have no objection. I'd also ask if I could address bond after we set that pretrial.
All right, Ms. McClure, anything we need to address from the people's side?
Nothing, thank you.
Let's go with September 11th at 8:15 then.
Yes, Your Honor. My office will do the SIP in order for that date and time.
Okay.
And Your Honor, Mr. Gritzmaker was asking the court if it would entertain the consideration of dropping the requirement for his scram unit and just having him do twice daily blows, either on a home unit, however he would accomplish that. Obviously, the cost of the GPS tether is not, I mean, he can afford the cost of it, although it's a burden. The more so burden is the impeding of him in his functions at work. It has been an issue with him at work. So he is hoping the court would consider that. I do believe there has been no issues since he's been on bond. Of course, we do understand that there has, the past criminal history do show a recent OWI. But I believe that, given the situation, it would be, it would alleviate the court's concern, again, having to do twice daily or even 3 times a day. That would alleviate the court's concern for the safety of himself and community without the requirement for the scram unit on. Thank you, Your Honor.
Ms. McClure, anything you want to say about the bond issue?
Mr. Banetto's the prosecutor on this, so I don't have, I don't know the facts of the case, but I can see on his CCH, this is his 5th OWI, and one fairly recent, this is his 2nd one within 2 years, but his 5th overall. So I think the scram unit is appropriate, and I would ask that it stay in place.
Right, I think the scram unit's appropriate under these circumstances as well. There is a OWI conviction from February 23 that happened in this court, and I think at this point that the needed for public safety requirement. There's obviously an issue with alcohol in this case, and I think that the heightened security of the scram is more appropriate.
Yes, Your Honor. Thank you.
All right, so Mr. Gritzmaker, your next date is September 11th at 8:15. You'll log in using all the same Zoom information that you used today.
You said 8:15, sir?
Correct.
I'll be in touch with you, Mr. Gritzmaker, okay?
All right, thank you.
Thank you, Your Honor.
And Mr. Murphy, I have Mr. Raymond here at the jail. Do you need to speak with him, or are you ready to?
We can proceed on the record, Your Honor.
So this is file 24-21890-FH People versus William Michael Raymond. Here today for an arraignment in this case and proceeding today by video conference. First, let me have the attorneys place their appearance on the record.
D.B. McCormick of the People.
Matthew Murphy appearing back from Mr. Raymond.
All right, and this is an arraignment in this case, Mr. Murphy. So does Mr. Raymond wish to have the information read?
No, Your Honor, at this time, we waive a reading of the information. We acknowledge receipt of said information, the witness list, and discovery demand from the prosecution in this matter. We're to ask for an entrance and continuation of a not guilty plea. I believe Mr. Raymond has a pretrial next week, the 14th, with his other files. If this is reset for that same date, so we can have it on the same, continue moving forward. I'd also ask if we could address bond on this matter.
All right, so enter not guilty plea, all set for pretrial on August 14th to go with his other cases. And what is it you'd like to say about bond?
Your Honor, on the other files, Your Honor was gracious enough to allow Mr. Raymond to be released on a PR bond if he was to have a tether in place. We would ask that that bond condition be applied to this file as well, so that if he was able to get a GPS tether, he could be released on a PR bond.
Okay, Ms. McClure, anything you want to discuss regarding bond?
Before it looked like they had amended his bond to allow him to go to inpatient, and that happened, but then he left on his own after only a couple days. That was with a GPS tether in place that he never got put on. Back in the note I have is back from July that he never got put on. He also has at one point showed up for court and then left the courthouse. So I would just ask, given his history the past couple months, that bond remain in place on this case.
So what the bond over says he has a PR bond.
Your Honor, I'm pretty sure that Judge Shaver, because I have my notes, I'd asked for a TR bond with GPS tether and she denied changing the bond. From what I thought, which is why I addressed it now. If it is the case, then obviously I'd ask that to stay in place. Because I know that Your Honor had given the condition on the other file that he has to have a GPS tether in place before he can be released. So that's why I was asking for it to be mirrored on this one as well.
I have that at bind over, it was set at 10,000 cash or surety with drug testing conditions.
Your Honor, can I speak with my attorney for a minute?
We'll go set up on Zoom, Your Honor.
Give us one moment, Mr. Raymond. Mr.
thank you.
Murphy's going to log in and we'll put you in a breakout session with him.
Thank you, Your Honor.
Okay, so on Heath Hall, we don't have anyone from MDOC logged in and there was no writ for him. So Ms. McClure, Ms. Underwood, I think we just need to identify another date.
Okay, thank you, Your Honor.
So I just got a second amended information on Mr. Highland. Has that changed from the one that was sent 15 minutes ago?
No, I think it's the same one. Count
Well-
6 is,
The date of offense, we changed the date of offense. It should say October 26th and 27th.
well, that's what I have on mine.
Both of mine say that, so.
Maybe one was filed and then I emailed it to just so everyone had it handy.
Mr. Highland, I've sent you a request to start your video and unmute your device, please.
Yes, get Nancy, please. Excuse me for a second.
Okay, so we're on the record now in file 23-21536-FH, People of the State of Michigan versus Matthew Lee Highland. We're here today for a pretrial conference in this case, and we're proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Mr. McCready.
Dave McCready for the people.
Dan Sala on behalf of Mr. Highland. Good morning, Your Honor.
All right, and so we do have a copy of a plea agreement and an amended information that's been sent this morning. Are we ready to proceed with the plea then?
Yes, Your Honor.
All right, Mr. Sala, you want to state the agreement for the record? I'll just ask Mr. McCready to confirm that.
Thank you, Your Honor. My understanding is, as part of the plea agreement, is written out that Mr. Highland will enter a plea of no contest to false pretenses between $200 and $1,000. There is a 30-day suspended sentence and probation. It's a Cobb's plea and/or Killebrew, and there's conditions of no contact after the plea. And yes, I've also submitted a proposed page of the police report to establish the factual basis.
It's actually a 60-day suspended sentence.
What did I say? I didn't say
30.
60?
You said
Okay,
30.
60, sorry.
Nice try, though.
All right, and that would be a Killebrew agreement that the court's not made any Cobb's evaluation in this case.
Correct.
Correct.
Okay. All right, so with that correction, Mr. McCready, is that a complete and accurate statement of the agreement?
Yes.
Mr. Highland, will you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Matthew Lee Highland?
Yes, Your Honor.
Mr. Highland, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest today to count 5 on the amended information, false pretenses of $200 or more, but less than $1,000?
Yes, Your Honor.
You understand that the maximum possible penalty for that offense is up to 1 year in jail or a $2,000 fine, or 3 times the value of what was taken, whichever is greater in terms of the fine.
Yes, Your Honor.
Are you satisfied with Mr. Sala and the advice that he's given you?
Yes.
Other than as we've discussed it on the record today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed. Correct, Mr. McCready?
Yes, correct.
Mr. Sala?
That is correct, Your Honor.
Is that also your understanding, Mr. Highland?
Yes.
If the guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them.
I didn't plead guilty.
You said guilty, Your Honor, of the no contest.
I apologize, I misspoke.
No, okay.
So if your no contest plea is accepted, there'll be no trial. Again, that means you'll be giving up the rights that you would have had at trial, so I'm going to explain those rights to you now. You do have a right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Highland, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, I understand.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, I understand.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No, Your Honor.
And do you understand that you're giving those rights up?
Yes, I do.
How do you wish to plead to the charge that on or about October 26, 2021 through October 27, 2021, in the township of Rome, county of Lenawee, that you did commit the offense of false pretenses, $200 or more, but less than $1,000?
I'll plead no contest, Your Honor.
Has anyone made any threats or promises to you to get you to plead no contest to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes, I do. I agree.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Highland to plead no contest?
No, Your Honor.
None, Your Honor.
Mr. Highland, other than as we've discussed on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
Can you repeat that, please?
Other than as we've discussed on the record this morning, has your attorney promised you any particular sentence or estimated what the sentence would be?
No. No, Your Honor.
Is it your own choice to plead no contests today?
Yes, it is.
All right. Mr. McCready, Mr. Sala, how are we establishing the factual basis?
I have provided a copy of the page of the police report through the court's legal assistant, Sierra McCrane, and Mr. McCready has the same page as well. I can establish that factual basis if the court would like.
All right, is that satisfactory to you, Mr. McCready?
Yes, the page in question indicates that the crime occurred at 12654 Forester Road. We just need to stipulate that that is in Clayton, Michigan, which is in Lenawee County.
And we would stipulate to that.
Okay. All right, you can proceed then, Mr. Sala.
Thank you. Pursuant to the police report, the officer writes, and it states that Matt stated he would send her a check for $10,000 from his business to help her as long as she would send him $200 once she cashed the check. Matt then asked Karen to send him the picture and that he would send the check. After that, Karen sent the selfie, and on 10/26, she received a check for $10,000 and attempted to cash it and withdrew $200 worth from that check.
And the check turned out to be fraudulent.
And the check was fraudulent, yes. TLC Credit Union, Karen stated that the check was fraudulent.
All right, Mr. McCready, are people satisfied with the factual basis?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes.
Mr. Sala?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Highland has had full knowledge of his rights. He's had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've discussed on the record this morning. I will refer this matter to the district court probation office for a pre-sentence investigation, and we will set sentencing for September 6th at 8:15 a.m. Mr. Highland, you'll need to report to the District Court Probation Office to Mr. McCarron on this coming Tuesday. That's August 13th at 8 a.m.
Okay.
All right, so we are all set then, Mr. Highland. You can go ahead and log out.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Thank you, Honor.
Thank you, Mr. McCready.
You too, Mr.
Mr.
Sal.
Murphy, Mr. Murphy, ready to proceed with Mr. Raymond then?
Yes, Your Honor.
I don't want it to, I'm done.
Mr. Raymond was just wanting to make sure clarification as to it. I think the GPS tether is ultimately a moot point. He can't afford it on his other files, so he wouldn't be able to afford it on this file. He wants to make sure that he doesn't have a PR bond, meaning he wants to make sure he's getting credit. If we just get clarification on that issue.
Okay. So while you were in the breakout session, our register of acts, I'm looking at the actual bind over original document that was signed by Judge Schaefer, and that indicates a personal recognizance. Our computer system indicates personal recognizance bond and that it's posted. So that, yeah, if you want me to set a bond so that he'll get credit.
Yes, can we do that, please, Your Honor? Just a nominal bond, I guess.
All right, so we'll set a $100 bond on this case.
Thank you, Your Honor.
So I think we are,
Sorry about that.
I think we're all set then.
Yes, Your Honor, thank you.
Thank you.
Mr. Raymond, I'm gonna talk with you on Friday in district court, okay?
All right, thank you. You're all set with me, Your Honor?
Yes, you could let the officer with you know that you're done with court.
All right, thank you, Your Honor.
I don't know.
Ms. McClure, are you there?
Yes.
Okay, so Mr. Hall, we didn't have a writ on and there's no one from MDOC logged in. So we just need to identify a new date for that. Can we do, Ms. Underwood, in the courtroom is September 11th, okay for that one?
That works,
Yeah,
Your
I
Honor.
will make a note of that and request a writ.
And so you're ready on Ms. Pawson, Ms. Underwood?
I'm sorry?
You're ready on Ms. Pawson?
Yes, Your Honor, thank you.
All right, this is file, oh, sorry. This is file 24-51606-PH, Jessica Lynn Oops versus Janessa Lene Pawson. We're here today for a personal protection order of alleged violation. We are proceeding today by video conference and in person. Ms. Underwood, you want to place your appearance on the record?
Rhonda Underwood for Ms. Poston this morning. And I'll start by saying, Your Honor, Ms. Poston is hearing impaired, as the court is aware, and she does read lips, however. Your Honor, Ms. Poston, this is a first. Ms. Poston has tried to make an appointment with my office, but she works 2 jobs and she could not come up with the time. I've spoken to her this morning. This is our first time talking. It went extremely well, but I need for Ms. Poston to come in. We've arrived at some times that would be good for both of us. So I would ask for 1 adjournment on this, Your Honor. And Ms. Poston and her companion have agreed to come in, and we should be able to proceed with what we're going to do on this show.
Okay, so you have an appointment scheduled.
She is going to schedule one for an early afternoon. Correct.
Okay, so this has been, the first hearing that we had on this was June 12th. So this has been pending a while.
Okay.
So this will be the last adjournment that we're going to have.
And we understand, Your Honor.
Okay. So I'll set this one out to September 11th at 8:15.
Thank you for the court's patience, Your Honor.
And I just want to be clear, if the matter is not resolved at that point, I'm going to set it for a hearing and we'll move forward one way or the other.
Thank you, Your Honor.
All right. Thank you. And you were ready on Nash as well? You ready on Nash as well?
Yes.
File 24-21852-FH, People versus Tanya Lynn Nash. We are here today for a pretrial conference. In this case, we are proceeding today partially in person and partially by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
BB McClure, map the people.
Rhonda Underwood for Ms. Nash this morning, Your Honor.
All right, and where do we stand with Ms. Nash's case today?
I believe the court may have a copy of an amended information in the file that Mr. Bayonetto may have done yesterday.
I do have an amended, yeah.
And if I could ask the court, I forwarded a copy of the plea agreement to Ms. Clark's email, Your Honor. So if we could have that, we could sign that and proceed with the plea in this matter, Your Honor.
So you forwarded, you sent what?
A copy of the plea agreement to court staff's email, Francis's email.
If you want to approach.
Thank you, Your Honor.
Ms. McClure, are you trying to log in with a second device or?
No.
Okay. Oh, I'm sorry, I'm looking at my screen wrong. I apologize.
Yeah, coach.
All right, Ms. Underwood, you want to state the terms of the agreement, and then I'll ask Ms. Brewer to confirm.
Ms. Nash will be pleading guilty to an added count of use of cocaine, 1 year misdemeanor. Oh, I'm sorry. I believe it. Okay. Spots on you, Your Honor. And the other counts will be dismissed. Prosecution has no objection to a 7411 if eligible, and we can't imagine why she wouldn't be.
All right, Ms. McClure, is that a complete and accurate statement of the plea agreement?
I also have down that she's pleading to count 3 retail fraud 2nd degree.
I'm sorry, Mr. McClure, I couldn't hear you.
I also have that she's pleading to count 3 retail fraud 2nd degree. That's in the plea agreement I have dated yesterday.
Plea agreement that has been handed to me indicates that she would plead guilty to count 3 as charged and an added count 4 of use with no objection to 7411 if eligible.
Right. I'm sorry, yeah, Your Honor, yes, the retail fraud.
All right. Okay, so Ms. McClure, with that correction, then is that a complete and accurate statement of the plea agreement?
Yes.
Ms. Nash, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Tanya Lynn Nash?
Yes.
Ms. Nash, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 3 retail fraud 2nd degree?
Yes.
Do you understand the maximum possible penalty for that offense is up to 1 year in jail and or $2,000 fine, or 3 times the value of the property that was stolen, whichever is greater?
Yes.
Is also your intention to plead guilty today to count 4 use of a controlled substance?
Yes.
And you understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $1,000 fine?
Yes.
Okay. Are you satisfied with Ms. Underwood and the advice she's given?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we discussed on the record this morning. Is that correct, Ms. McClure?
That is correct.
That's correct.
All right. Is that also your understanding, Ms. Nash?
Yes.
If guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Nash, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about January 13, 2024, in Madison Township, Lenawee County, Michigan, you did commit the offense of second-degree retail fraud?
Guilty.
And how do you wish to plead to the charge that on or about January 13, 2024, in Madison Township, Lenawee County, Michigan, you did commit the offense of the use of a controlled substance?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that your pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the pleas?
Yes.
Is prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Nash to plead guilty?
None, Your Honor.
No, Your Honor.
Ms. Nash, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty?
Yes.
Ms. Underwood, do you want to cover the factual basis?
Ms. Nash, let me take you back to January 13, 2024. Were you in Madison Township, County of Lenawee?
Yes.
And you went to the store? What store was that? And while at Walmart, did you take items that were for sale there?
Yes.
And you did not pay for those items?
Correct.
And you did not intend to pay for those items? And Walmart is a store in Madison Township that is open for business?
Yes.
And when you were confronted about these issues, you had in your possession Suboxone, is that the case?
Yes.
And you don't have or didn't have a valid prescription for that, is that the case?
But I didn't have a valid prescription.
And under those circumstances, it's illegal to possess that controlled substance, correct? I believe we've established the facts, Your Honor.
Ms. McClure, are you satisfied with the factual basis?
Was the value of the property from Walmart, was it more than $200?
I'm not sure, actually. I believe so. Maybe.
Oh, is that a yes?
Yes.
Okay, and was it your intent to use the Suboxone you had in your possession?
Yes.
Okay, satisfied with the factual basis.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
It has.
All right, I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Ms. Nash has had full knowledge of her rights and she's had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone interested in any of them. I will refer this matter to the district court probation office. And we'll set sentencing for September 6th at 8:15 a.m. Ms. Nash, you will need to report to the district court probation office on Tuesday, see Mr. McCarron, the District Court Probation Office on Tuesday at 8 a.m. All right, and so Ms. Underwood, she also had a show cause related to drug screening, so Ms. Nash, have you received a copy of the order to show cause?
I believe so, yes.
Okay. So the show cause alleges that you violated the terms of your probation. Or I'm sorry, Mr. Coach, have the issues with respect to the show cause, those have been resolved?
I believe so, Judge. She was missing
Okay.
drug tests over at the drug testing facility, but we have made other arrangements where she will be testing at the courthouse. And she has since supplied me with proof of hospitalization and also a good phone number. So I'm okay with that being dismissed at this time.
All right, so I'll dismiss that. You had also indicated that so Ms. Nash has prescriptions for both hydrocodone and Suboxone.
Correct, which obviously I have a concern with her taking a opiate-based medication. She did take a drug screen though last Friday. The only thing was positive was the THC, however.
All right.
The Suboxone prescription is no longer valid. I canceled that.
Are you taking the hydrocodone now?
Just when needed. It was only a prescription from the hospital doctor. It's not something I had like regularly. I also have an appointment set up with the family medical center, so.
Okay. I mean, obviously the concern is that the Suboxone is used to treat an opioid problem and the hydrocodone is an opioid.
Mhm.
And
I asked that she prescribe me very few of them.
all right.
And that's why she prescribed a Motrin with it. It's on the proof that I sent Mr. Most as well.
All right, so not going to do anything with that for now, so you'll just need to see Mr. McCarron on Tuesday at 8 a.m. Okay, so we're all set.
Thank you, Your Honor. Thank you.
Okay, Mr. Dagger Margosian, are you ready to proceed with Mr. Lindeman?
Yes, Your Honor.
This is file 24-21858-FH, People versus Mason Bradley Lindeman. We're here today for a pretrial conference in this case. We're proceeding today by video conference. First, let me have the attorneys place their appearance on the record.
B.B. McClure, map the people.
Your Honor, Michael Dagger Margosian for Mr. Lindeman.
All right, and so where do we stand, Mr. Dagger Margosian, in this case today?
Your Honor, Mr. Lindeman has a jury trial date on a different allegation. This case, the result of it may be contingent on the result of that jury trial. So I'd ask the court to adjourn this case past that jury trial. I think the jury trial is sometime in September. I don't know the exact date.
Judge, his home invasion jury trial is September 10th and 11th. So I would agree to put this out past that jury trial date.
Okay. Let's set it then for September 18th at 8:15. And Mr. Dagger Magosian, would you do that stipulation in order, please?
Yes, Your Honor.
Okay. Is there anything else we need to address with this case?
Just because a record was made in district court, I just wanted to address one thing. The district court judge had ordered us to provide an evidence log for the suspected controlled substances in this case. And that has been done at this time. So I just wanted to confirm on the record that we're compliant with that and that Mr. Dagger Margosian has that.
I don't see any notes added to this file by our staff, but if it's been sent over by the prosecutor's office, I'll look into that.
All right.
I don't see any additional documents added to this file.
It was, okay, it was sent, so it was sent about a month ago, so just, I guess, let me know if you don't have it and I'll resend it.
Okay, well, I'll touch base with you.
Thank you.
Okay, so Mr. Lindeman, you can let the officer with you know that you're done with court for today. Mr. Murphy, is Mr. Parrish here?
Yes, Your Honor, we're ready to proceed, Your Honor.
Okay, this is file 24-21846-FH, People versus Deshaun Michael Parrish. We're here today for a pretrial conference in this case, and we're proceeding today partially in person, partially by video conference. First, let me ask the attorneys place their appearances on the record, beginning with Ms. McClure.
E.B. McClure, may I have the people?
Matthew Murphy, appearing on behalf of Mr. Parrish.
And Mr. Murphy, where do we stand with Mr. Parrish's case today?
Your Honor, we're going to ask to set a jury trial on this matter. We're going to ask for a 2-day jury trial. And then I was going to ask to address the bond condition of a GPS tether on Mr. Parrish.
Okay, so Francis, we'll need a 2-day jury trial date, please.
Tuesday, December 3rd at 9 a.m. and Wednesday, December 4th at 10:30.
That works for the defense, Your Honor.
Could you tell me that date one more time? I'm sorry.
December 3rd at 9 a.m. and December 4th at 10:30.
So this is Mr. Banetto's case, and at this point he has a 2-day jury trial set in district court. That, I mean, it's hard to say whether that's going or not, but he is unavailable as of today.
December 5th at 9 a.m. and December 6th at 9 a.m.
That works for the defense.
Looks like he is unavailable on the 6th.
December 10th at 9 a.m. and December 11th at 10:30 a.m.
That works.
Okay.
Sorry.
Defense, thank you.
Okay, so let's do a final pretrial then on December 4th.
Thank you, Your Honor.
All right, what is it you wanted to say about bond, Mr. Murphy?
Your Honor, down in district court, Mr. Parrish was given a a GPS tether. He wasn't only allowed to have a PR bond with the placement of a GPS tether. Now, Mr. Parrish, his criminal history, he has 2 priors, I believe, but domestic violence in 2019 is the most recent case. Misdemeanor charge. This is an embezzling charge. He has no record of absconding or trying to escape jurisdiction or anything of that sort. He has no record on this file of trying to flee, of not appearing for court dates or anything. He's made all the appointments that I've tried to make with him at my office. He's not been unavailable in regards to communicating. I don't believe he's a flight risk, Your Honor. He's obviously here today in person. He could appear over Zoom in person, however the court would want him to. He knows his trial date. He knows the next pretrial date. He's here in person, giving the notice in person. So I don't believe he's a flight risk, Your Honor. I don't believe that a GPS tether is required to alleviate any concern of his appearance moving forward. And I don't believe it satisfied any function of the safety of community, because again, this is an embezzlement charge, and he's obviously not going back to the place where this occurred at. So I'd ask the court to consider removal of the GPS requirement at this time.
All right, Ms. McClure.
I would agree with Mr. Murphy as long as there's not been any violations to this date, and I don't see any noted in our file. So I would agree, just continued no contact with Lillian Cabinets.
And Judge, this, the GPS tether was ordered on June 13th, but when it was bound over to circuit court, I'm now the supervising agent. The only requirement is he's not to leave the state of Michigan. I have not received any violations thus far in this GPS.
Okay, so I will then remove the GPS tether requirement. All other requirements will remain in place.
Yes, Your Honor, thank you.
Hey, Deshaun, I'm going to go ahead and contact Don over at JSG. Go over there this morning and get that taken off.
All right, thank you.
Thank you, Your Honor. All right,
Okay, thank you. Let's see, Mr. Lyons, we have Mr. Shears here. You're gonna need a breakout session with him. Right.
Alex busy Wednesday morning, but do you have like less than 5 minutes to speak to Mr. Blake and that after?
Yeah, I can. Let me just figure out what George Lyons is going to do. Get his attention. Mr. Lyons, you're there. Oh, there you are. So do you need a breakout session with Mr. Shears?
If I may, please.
All right.
Approach, Your Honor.
Yes. Oh. Okay, Ms. Wise, Mr. Blake, you want to just come back?
Yes, please. Do you want us to walk around the long way or please? Yes.
Right here. It's closed. Yeah. I don't even have it in here yet. Tells me that it's that's when you what case is this? Nash and Crown. I did tell her that when you're sure. It's not. Did he say that he dismissed? Did he say when you did?
But there was one, there's one, he did dismiss it. Was there another, was there another one that he said he was gonna?
Was that the same?
Was it?
They talked about it.
Yeah, that's all right. I stopped.
Hang in there. It's crazy.
I don't know what the GPS because you already put GPS on the other files, right?
He did.
Okay.
So the issue of that case.
It was so weird because they were all on the same day as mine, so how do you know which one, like, I go in order?
What was that case?
Right here.
Because let me tell you, there's a Kentucky court.
So one of the other files? I mean, or this file? This is going over like the last thing they did, or that's like
The most first, this is the first thing, it's the first thing. This is there's a complaint. And then there's one.
But yeah, there's a contempt of court at the bottom, so that was the last thing. So it was like they give them a PR bond and everything else, but the contempt of court for not showing up for that arraignment, they said it at 10,000 or something, right? 500 at first. When was 500? Mhm.
All right. See you.
Okay, Mr. Lyons, are you ready to proceed with Mr. Shears?
Yes, I am, Your Honor, and good morning, Your Honor. May it please the court, George Lyons on behalf of Mr. Shears.
Okay, so this is file 24-21752 FH, People versus Frederick Khalil Shears. And so we arraigned Mr. Shears on a warrant for bond violations yesterday. And so Mr. Lyons, do you know how Mr. Shears wants to proceed on that today?
Yes, Your Honor, he tenders are not guilty or not responsible, asking that the matter be set for a hearing, Your Honor. And if there is a police report, we'd love to have the copy of it. All we have here is a two-line statement on the motion and affidavit. But as I understand, this is that the home where these drugs were found is not my client's home. And I further understand there was residual found on the floor, not on the person or within the wingspan of my client. That's just my understanding, Judge.
So let's see, how soon do you want that hearing scheduled?
When does the court usually do those, Judge?
I don't have a usual date or time. I just kind of plug them in where we can.
Okay. May I suggest, boy, the next free morning, Your Honor, is next Wednesday.
And I apologize, Ms. Arnold, I forgot to have you place your appearance on the record.
Allison Arnold for the people.
All right.
That's not true, Your Honor. That day I'm in Westland. Is the court limited to doing these in the AM?
I'm sorry?
Is the court limited to doing these things in the morning?
No.
Most afternoons I'm free, Your Honor, after 1 o'clock.
Okay. So let's see, Francis, could we try to find a hearing date? We'll probably need about an hour. Is that fair?
Should be enough, Your Honor.
Judge, I believe Mr. Shears is likely to be charged with some additional offenses in the next couple days. So I would expect a PCC on that stuff in the next couple weeks. So I'm not sure how far the court wants to go out.
My question is there a police report available? Or probable cause sheet, anything?
Honestly, I didn't even have notice of this hearing. I just happened to be on the, hang on. Let me see if.
There is a probable cause affidavit that we could email to you, Mr. Lyons.
Well, let me double check, Your Honor. I've got, I have the motion affidavit and bench warrant. I'm afraid that I do not have. I literally only have the motion affidavit and bench warrant.
Okay, we can email that to you right now.
I can check my spam.
Is there any way y'all can send me one over here?
I want you to be quiet right now, Frederick, please.
Okay.
Yeah, I don't believe we have the report. At least it hasn't been assigned to a prosecutor yet, it doesn't look like, but I would expect we would get it today or tomorrow.
Yeah, she said that.
Judge, for that date, August 15th at 1:30.
Okay. It's a week from tomorrow. Okay, I got the proper call sheet, Your Honor.
Right?
Your Honor, if I may trouble the court to go back into a breakout with Mr. Shear.
Yeah.
Thank you, Judge.
Mr. Glazer, are you expecting any of your other people in person?
Prophet is supposed to be here and he's not, and Nymer's supposed to be here and he's not.
They have last terms. I'm sorry, Ms. Dumont, what cases are you here for?
And I'm covering for Mr. Daly for Nathan Edwards.
Okay.
I don't believe he appeared, and I think he has a bench warrant.
Yeah, let me call that real quick, just so we can make a record of it. Okay, so this is file 24-21785-FH, 24-28781-FH, 24-21782-FH, 24-21783-FH, and 24-21784-FH. People versus Nathan Wayne Edwards. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. McCready.
Dave McCready for the people.
Katerina Dumont for Mr. Edwards.
Okay, and this was set for a pretrial today. At the last pretrial, Mr. Edwards, on July 24th, Mr. Edwards did not appear. The court issued a bench warrant in the 24 file, which was the file set for trial, actually in all of the files at that time. I think we just left this on to see if somehow he might appear and we could leave our trial date intact. Was that correct?
That's correct.
Yes.
Okay, so he has not appeared here today either by Zoom or by video conference. So at this point, court will vacate that trial date and we will allow the bench warrants to remain and will proceed at such time as he's picked up on the bench warrants.
Thank you, Your Honor.
Thank you.
Okay, thank you. And then you were here for Mr. Paulding as well?
Not that I'm aware of.
We had, yeah, an arraignment for Cole Paulding.
I can cover.
Don't have Mr. Paulding.
Okay. Let me check real quick.
Yeah,
Yeah,
okay.
right back.
Oh, and I'm sorry, Mr. Bennett. We do not have Mr. Jones. Do you have you had any communication with him, or do you know if he's showing up today?
Your Honor, yeah, I spoke with him last night. I sent him a text early this morning. He said he's about to sign in. And if I recall correctly, he has an iPhone, so I don't know if you know who that is, but that may very well be him that's having an issue connecting.
You do have someone who's just named iPhone. His audio is not connected right now, so we have no way of communicating with him.
I just sent him another text, Your Honor, to see if he's having problems.
Okay, Mr. Liz, you want to call the Profit and Niner cases?
Profit?
Do you want to call those now, or?
Yeah, that's fine.
Okay. So Profit, first of file 24-1856-FH People versus Mason James Profit. Today is the date set for a pretrial conference. In this case, we are proceeding today in person and by video conference. First, let me ask the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, map the people.
John Glazier on behalf of Mr. Profit.
All right, and record to reflect this was set for pretrial this morning at 8:15 a.m. It's currently 10:12 a.m. Mr. Profit is not present either personally in the courtroom or by Zoom and has not been present at any point this morning. Mr. Glazier, anything you want to say with respect to Mr. Profit?
Your Honor, I don't know where he's at. I had a phone number for him and I tried calling it and it said it wouldn't go through for some reason. So I called my secretary, Leo. Leo called it and said it wasn't accepting any voicemails. So I don't know where Mr. Profit is. I would know, Your Honor, if you're gonna issue a bench warrant, maybe you could hold it till noon or not sign it until noon. He has pretrial set down in district court at 11:30 as well. And maybe he'll show up with those. I don't know.
Okay, I would also indicate for the record that Mr. Profit had an order to show cause requiring his personal appearance this morning relative to an allegation that he violated bond conditions by testing positive for THC and cocaine on July 29th. So what I will do is it would be first failure to appear for the underlying case. So have to wait the 48 hours before issuing a bench warrant for failure to appear here today on a pretrial. So at this point, I'll just wait the 48 hours. If he hasn't appeared, I'll issue a bench warrant for his arrest for the failure to appear.
If he shows up down there, I'll let the court know right away.
Yeah, it's set bond, revoke and forfeit on the bond that he has, and I would set bond on bench warrant in $50,000. Okay, and
Yes, hello. Yeah.
oh, okay, give me just a minute, Mr. Jones. Okay, so this is file 24-21792-FH, People versus Bailey Assad Neimer. We're here today for a pretrial conference in this case, and we are proceeding today by video conference and in person. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, may I have the people?
John Glazier on behalf of Mr. Bank.
And record should reflect this was set for pretrial at 8:15 a.m. It is now 10:15 a.m. Mr. Neimer has not appeared either personally in the courtroom or by logging in on Zoom. Mr. Glazier, anything you want to say about Mr. Neimer?
I just have a second to make sure this is Mr. Neimer.
Judge, if I could just jump in and say, he does have an arraignment on 2 other related felonies set for next week, August 14th. I don't know if we want to just adjourn this arraignment to that day and see if he appears then. Or I guess it's a pretrial, not an arraignment, but either way. I know Mr. Sneed had reached out asking for a stip in order to adjourn and hadn't heard back, so.
Your Honor, I'm looking at my notes, and on the 24th, we had a pretrial by Zoom, and it said arraignment adjourned to 8:14 and 8:15. And I put send him a letter. Now, I don't have a copy of the letter, but Leo may have sent him a letter to be
Tell him 14th. Okay. All right, so let's adjourn it then to the 14th, August 14th at 8:15 a.m. To be consistent with his other cases, and we'll see if he appears at that time.
I don't know how this got to. All right, I think that's all I have.
Okay, thank you, Mr. All right, Mr. Lyons, are you ready to proceed with Mr. Shears again?
Your Honor, having had a chance to review the probable cause sheet, respectfully, I'm going to ask the court to adjourn this matter out. If they're going to be charging him, Your Honor, that puts everything in a different light. Yeah, I don't want to move forward and put my client at jeopardy.
So what I'll do is, how far out did you want to look for a date, Mr. Lyons?
Wilson, do you have a general idea of when he may be charging him?
I would expect it would happen this week.
Your Honor, could we put him out maybe a week just as a control date?
Our next pretrial is September 4th at 8:15. I don't know if you want to keep that date and we can move it up if we need to, but that doesn't sound like by then I think we would know what's going on with the new charges.
All right, that sounds fair. I
have an arraignment on the 3rd. I mean, a pretrial for the what I'm on bond for on the 3rd.
I know that, man. I need you just to be quiet, Fred, please.
Okay.
Okay, so I'm sorry, did I hear agreement to set it for the September 4th with the already existing pretrial? Or do you want it sooner than that?
I'd probably be asking for maybe 2 weeks, Your Honor? I know I'm in front of you on the 28th.
We can do the 28th.
Yeah,
Okay, so
I set bond, Your Honor.
we'll set it then for August 28th at 8:15.
Thank you. May I address bond, Your Honor?
Okay.
Presently, the bond pursuant to the probable cause sheet and bench warrant is set at $100,000 surety, Your Honor. If in arguendo the allegations are true, the 100,000 cash surety is still more punitive, Your Honor, than anything else. This young man has never missed court. He doesn't. There's no allegations of weapons, no allegations of violent behavior, and we do dispute the allegations herein. We're asking for a more reasonable bond.
Ms. Arnold, anything you want to say?
Judge, we believe the bond's completely reasonable. The defendant's out on bond for a major controlled substance felony, which means any new charges would be mandatory consecutive. He has a prior conviction for delivery, manufacture cocaine, heroin, or another narcotic, 50 to 449 grams, that he went to prison for 7 years, has multiple resisting and obstructing, crimes of violence. And he was located coming out of a bathroom in which there were 22 grams of cocaine, and they were, it was scattered about as if he was trying to get rid of it. I think the bond is appropriate.
Just to clear this up, the 22 grams was found on the floor in the living area. There are
Oh, wait,
allegations.
hang on. Sorry.
That's okay. I think we both kind of read this thing on the fly. But there were no drugs found on his person, Your Honor. And I think the facts are going to hold out that who lived there was his child's mother and his minor child, not Mr. Shearer. But these are things that will come out if there's a PCC or we have a hearing, Your Honor.
Right. According to the PCC sheet, and I haven't seen the police report yet, 22 grams of cocaine in a tied off baggie, which tested positive, was located in the bathroom. When the police went into the residence, Frederick Shears was observed exiting the bathroom. There was also white residue powder scattered on the floor around the toilet, which tested positive. And there were other allegations that resulted in a search warrant being issued for that residence based on Mr. Shear's activity.
Yes, we're reading different reports. There's absolutely nothing in here that says that 22 grams of cocaine were found in the bathroom where my client was. That's just not true. And I refer you to page 2, paragraph 1.
I'm just reading. During the search of the bathroom, detectives located the following items. 1, 22.8 grams of cocaine in a tied-off baggie, which tested positive for cocaine with the TrueNarc analyzer. Maybe I can't believe my lying eyes, but that's what I read.
Well, then you should chastise your lying eyes then.
Well, where, Mr. Lyons, does it say it was somewhere other than the bathroom?
Again, I'm reading it on the fly, Your Honor. It says my client was seen leaving or exiting the bathroom. He was placed in handcuffs. He says 22.8 grams of cocaine in a tied-off baggie, which tested positive for narcotics, cocaine, pursuant to the TrueNarc.
Okay, and just above that, it says during the search of the bathroom, detectives located the following items, colon.
I misjudged.
Okay, so
it's just a constant. Then I blame my lying eyes and not yours.
All right, so in looking at the file, Mr. Shears was out on bond in this case on charges of delivery, manufacture, of cocaine, heroin, and other narcotic less than 50 grams. Also charged with a felony firearm and possession of a firearm by a felon. In the fourth habitual offender notice, it indicates that Mr. Shears has previous conviction for delivery or manufacture of cocaine, heroin, and other narcotic of 50 to 449 grams. And in this situation was located in a residence with another significant amount of cocaine. And so I think that I agree with the prosecutor's logic on this case that public safety requires a significant bond in this case. And as a result, I think it's appropriately set, and I'm going to decline the request to modify the bond.
Your Honor, as soon as I get the police report, I'll come to see you with a copy, Fred.
All right, thank you.
Thank you, Judge.
So, Mr. Shears, you can let them know you're done with court for today. Mr.
Okay,
Malero,
thank you.
Mr. Malero, do you need a breakout session with Mr. Madrid? Apparently I've lost Mr. Malero. Mr. Bennett, are you ready to proceed with Mr. Jones?
Yes, Your Honor.
All right, this is file, wrong file, sorry. Files 23-21615-FH and 23-21616-FH, People versus Maurice Leroy Jones. We are here today for final pretrial conferences, or final pretrial conference in the 615 case and a pretrial on the 616 case, along with a pending pretrial and contempt of court for alleged violation of bond conditions. First, let me have the attorneys place their appearances on the record, beginning with Ms. Arnold.
Allison Arnold for the People.
Morning, Your Honor. For the record, my name is Jeffrey Bennett, appearing with and on behalf of Maurice Jones today.
Maurice Jones. Mr. Jones is here by video conference as well. All right, is there anything we need to address today from a pretrial standpoint?
Your Honor,
Judge, go ahead.
Your Honor, I filed a motion in limine after the people filed a 404B notice. I received a response to that motion last night or yesterday afternoon, I think at 3:45. So I believe that Ms. Arnold and I both are in agreement that that needs to be decided. The issue is going to be, if granted, the 616 case should go to trial, I think, at the same time, since it's pending. And the problem is going to be there's an uncharged case that is going to come in at trial. And that would put Mr. Jones in jeopardy of having to face the exact same testimony in two separate trials. So I'm not sure how we want to go forward, certainly with the two cases, if you deny my motion in limine.
Good. Judge, and we apologize, I guess, for filing it yesterday. We received Mr. Bennett's motion in limine, I believe, on Friday, and I filed a response as quick as I could, hoping that we could address this either today or soon afterwards. I think there's great reason for the 404B evidence to come in, and if it does, we don't object to trying both cases 615 and 616 together on the scheduled trial date of August 20th, which would be Mr. Bennett's suggestion. There was an offense. This happened, the charged offense was in August, and the other offense, off the top of my head, I believe was in November of 2023. In any event, it was a couple months afterwards. And the reason we have not charged that offense yet is we're still waiting for phone analysis from MSP Computer Crimes Unit. But in speaking to Mr. Bennett, I believe if we did try 615 and 616 and there was a conviction, that we may agree not to authorize that other charge, or it certainly might be easy to resolve that other charge. So our preference would be to have the court rule on the 404B issue and then to proceed to trial on the 20th. I did want to put on the record, Mr. Bennett filed a notice of objection to lab reports for the 404B incidents. That was timely filed, so we would be calling both Daniel Case and Scott Pennebaker at trial if the 404B issue is granted. However, we have listed Jessica Pisarski, and Mr. Bennett and I talked, and the notice of intent to use her was timely filed with the PD's office back at the beginning of the case. He has not filed an objection to that because that was timely filed, and we would not be calling her at trial because her report would come in pursuant to that notice statute. The only other issue is there is a bond violation that we need to address.
And as it relates to the not objecting to the notice of intent in the 615 case, I was not the attorney at the time the discovery was provided. In fact, I just discovered I don't have the lab report, but assuming that the notice was filed after the lab report was created, I think that Ms. Arnold and I are in agreement that no timely objection was filed.
So I have not received a copy of the prosecutor's response to the motion. I did get the motion. I have reviewed that.
Judge, I emailed it. Oh, sorry, I emailed it. Go ahead.
You want to have further argument on that, or are you comfortable having me decide it on the written submissions?
I think you can decide it on the written submissions. And we did email a copy to both Ms. McGrain and Ms. Clark yesterday, hoping that you would get a copy sooner. We filed it, I think, about 4 o'clock yesterday afternoon. But the copy we emailed them, I think, didn't have the proof of service yet because it wasn't the filed copy.
All right, and so Mr. Bennett, did you want further argument on the motions, or were you okay with just deciding it on the written motion?
Your Honor, first of all, for the record, I would indicate at 3:45 yesterday, I received an email from the people with that motion, so I was certainly served with the motion regardless of when the proof of service is filed. I've had a chance to look at the people's response, and I believe that both sides are clear enough for the court to make a decision without further argument.
Okay. All right, so I can do that. I can probably have that order out to you before the end of the week. And then, so I guess, did I understand everyone correctly to say that if I allow the evidence, then you would want to try both of the cases at the same time? Is that correct?
That is, Your Honor. And if the court likes, we could do, depending on the outcome of that order, and Mr. Bennett and I could just submit a stipulation to try both of those cases together on the 20th, if that works for the court.
Or my suggestion would be to consider this an oral, a conditional oral motion and just put it in the order.
Yeah, that's fine too.
Okay, I can do that, that's fine, I just wanted to make sure that you were both in agreement with that, if that's what comes to pass, so. All right, so is there anything else that we need to address today?
The bond violation by Mr. Jones.
All right, so with respect to the bond violation, I am aware Mr. Coast requested another bench warrant based on another positive test that Mr. Jones had. And I believe I signed that yesterday. Is that correct, Mr. Coast?
You did, Judge. This is the third time in which he tested positive for cocaine. He did appear by Zoom back on March 27th, and you ordered him to turn himself in on the warrant, which he did not. And then we have yet another positive drug screen. So, I mean, I'd like to request, I mean, if he does have any additional hearings before you, that he appears in person for all hearings.
Can I address that, Your Honor?
Go ahead.
Your Honor, you just signed the bench warrant yesterday. This is the first time that I've heard about that. You indicated that you were going to sign the warrant on the date of the last pretrial, which you did not do. Mr. Jones and my office have been in contact with the court since March regarding both the warrant for him to turn himself in, as well as the additional charges that I understood from the pretrial that Ms. Arnold was going to file so that these three cases could get together. So Mr. Jones has been trying to turn himself in, but without a bench warrant, there's no way he can turn himself in. They won't take him. As to the positive test, this test was in March. Since this last positive test, he has no new positive tests. One of the significant changes is the person who collects the sample. The most recent test, there is, and I don't know if you can arraign him on this over the phone or over the Zoom call, but there is some photograph of the cup of the same urine by another person there that demonstrates that the test was in fact not positive.
Judge, the test he's referring to is he did test positive on July the 30th. That sample was sent to Millennium Labs, and that test did return back positive for cocaine.
All right, so I'm confused now because Mr. Bennett was talking about a test in March. So Mr. Bennett, which test are you talking about, the March or the July 30 test?
Well, you know what? It may have been the July 30th test.
No, I don't. I'm sorry. I don't have no negatives. I don't have no dirties in July at all. 0%. They thought my test was dirty, so they made me wait 10 extra minutes or 15 extra minutes because whatever time I came.
All right, so Mr. Jones, I need you to stop talking.
Yeah.
Okay. Because you potentially could say something to harm your position.
Okay.
So the warrant that I signed yesterday was for a positive test on July 30th. I just need to know from Mr. Bennett, you just went through some information about problems with a test and a person that was doing the testing, but that all, as I understand it, related to the March positive test.
Yes. I was not aware of an alleged positive test on July 30th. I didn't get it last time. The one in March, I received an email with the positive test, but I did not receive that this time. So this is the first time I'm hearing about an alleged positive test on July 30th.
All right, so that's obviously that's what I've signed the warrant for. So Mr. Jones is going to need to turn himself in on that.
Okay.
And
Will the,
I guess, I don't know if the court wants us to argue, I guess we'll argue about the bond after Mr. Jones turns himself in, correct?
Yeah,
yeah, that
I
was,
would ask that Mr. Jones be required to turn himself in by the end of the week. We do have a prior fail to appear by Mr. Jones in this file when we had preliminary exams set and had our witnesses present. He also did plead to contempt of court in district court for testing positive for drugs. So our concern is that he be here for the trial date and in a state that he can assist Mr. Bennett for trial.
and Your Honor, as far as missing the court date, that was when he was represented by prior counsel, and the reason that Mr. Jones sought out private counsel was because he was having communications issues with the prior attorney. He has appeared for every hearing since I've appeared in this case, and there have been many. So but I mean, if he's got to turn himself in, I think by the end of the week is appropriate. I would just ask to be notified of the arraignment so I can make a bond argument.
we can certainly get in touch with you as soon as that happens.
Thank you, Your Honor.
Judge, at this time, the warrant is not in lien. I'd request that this actually gets placed into lien.
I mean, if I signed it, that should all happen through the clerk's office.
Very good.
I don't think I need to do anything other than sign it for that to happen.
Correct. Thank you.
Okay,
Thank you, Your Honor.
all right, thank you. So Mr. Jones, you need to turn yourself in on that warrant. You're all set. You can log out for now.
Thanks, Judge.
Your Honor.
Mr. Malero, do you need a breakout session with Mr. Madrid?
No, Your Honor. Not unless he wants one.
Mr. Madrid, do you want to speak to Mr. Malero in a breakout room?
Yeah, that'd be fine, sir.
Okay, give me just a second here. Okay, let's see, Mr. Paulding.
Your Honor, I checked on that and it looks like on July 30th, we filed a waiver of arraignment. He came to our office and we discussed that and we signed waiver. And advised him he didn't need to appear.
Okay, I don't have a waiver in the file.
We do have a copy and I can bring one over today if that works as well.
Yeah, if you wouldn't mind, let's set it for a pretrial then on does September 11th work?
Yes, that works.
Set it for a pretrial on September 11th. And yeah, if you could bring a copy of that waiver over, I might still be in the clerk's office. I don't know, but usually they get those to the file. But
okay,
if you could bring a copy, I'd appreciate it.
Yep, I'll bring one today.
Okay, thank you.
Yep.
Okay, this is file 24-21750-FH, 22-20968-FH, and 22-20969-FH, and also 22-20972-FH. People versus Michael Anthony Madrid. We are here today for a pretrial conference in the case, as well as a pretrial on alleged violation of bond conditions for failing to appear on July 24th. Also for failing to drug test on June 25th and July 1st. First, let me ask the attorneys place their appearance on the record, beginning with Mr. McCready.
Dave McCready for the people.
Mr. Malero, I'm not able to hear you.
Can you hear me now, Judge?
Yep, now I can.
All right, yeah, Salvatore Malero on behalf of Mr. Madrid.
All right, and so where do we stand with Mr. Madrid's cases today? How do you want to proceed?
Judge is going to ask to adjourn these matters for like 2 weeks. Make sure everything's okay. There's no additional charges, and then I see if we can get this resolved.
So I can set it for August 21st at 8:15. That's 2 weeks.
That's fine, Judge.
Okay, is there anything else we need to address for today?
I'll do this step in order, Your Honor.
Okay, I would appreciate that. Mr. McCready, anything from the people's side?
No, Your Honor.
Mr. Madrid, you can let the officer with you then know that you're done with court for today.
Thank you. Thank you, Judge.
Thank you, Mr. Malero.
Thank you. Have a good day.
Thanks, you too.
In fact, you can hear me. Stupid fucking thing.
So do you learn anything about passports?
Questions we have WOC, the same questions with class plus. Get paid for 7 next week. You always go.
So we got Madison and Kate. So this file 23-21242. This is Madison. File 23-21242-FH, People versus Brandon Lorenz, Joe Madison. Here today for a hearing on a request and summons for probation violation. Record should reflect that Mr. Madison was required to appear this morning at 8:15 a.m. to respond to the summons for probation violation. It is now 10:47 a.m. Mr. Madison has not appeared either in person in the courtroom or by logging into the Zoom session. I am going to issue a bench warrant for his arrest for that failure to appear. I will set bond on the bench warrant in the amount of $50,000. Okay. And this is file 23-21419-FH, People versus Derek Eugene King. Record should reflect that Mr. King was ordered to appear this morning to respond to a summons for probation violation. It was scheduled for 8:15 a.m. It is now 10:47 a.m. Mr. King has not appeared either in person or by logging into the Zoom session. I'm going to issue a bench warrant for his arrest and set bond in the amount of $50,000.
Thank you.
And I think that is everything. You've got something.